So this is where PW has come up with a series for a rapid revision. Can either ratify when it comes to ordinary bill, return not money bill, and reject the bill. The pocket veto used once, in which the president can just stay quiet, keep the bill in the pocket and relax. No written procedure in the constitution about this very idea. What next? The powers of the assembly goes into the parliament. Now parliament takes control. Now the Supreme Court, it recently said that we need to take care of the Gram Nyayalayas, we need to do the audit of the Gram Nyayalayas, we need to see that whether they are functioning as per the act or not. Consumer Protection Authority has also come up with a report that... Hello everyone, this is me 𝐂𝐃𝐀𝐍𝐃𝐄𝐃. I welcome you all to PW UPSC Wala English. Friends, as we know that we have just a week in hand, so this makes us very jittery that how we would be able to cover everything in the last 1 week. So this is where PW has come up with a series for a rapid revision. In this rapid revision series, we would be discussing the current affairs. At the same time, we would be linking the current affairs with the static part. My objective for this video would be to make sure that all the static sections of that very topic are covered thoroughly. So having said that, I'll not waste much of your time. Let us start the session. Topic number 1 is with regard to the assent to the bill's veto power. When it comes to the assent, we know that president or the governor respectively have a power to assent the bill. While granting them this power, the constitution also told them that you have certain other powers as well. That is, you can suspend the bill, you can send it back, return the bill, you can withhold the assent, you can not just make sure that assent has not been given, or you can completely reject the bill. You can say no to the bill. So this is where these kinds of powers have been granted to the President of India, in which the President of India, with regard to certain bills, can either ratify when it comes to ordinary bill, return not money bill, and reject the bill. When it comes to money bill, obviously ratify, reject, and return is not possible. And this is where the powers come. Similarly, when it comes to the constitutional amendment bill, it can be rejected, or it cannot be rejected, or it cannot be returned. It has to be assented. No other power with this. So quickly recap that these kinds of powers have been given. Now why these powers have been given? Because so that the president is able to make sure that the laws of the parliament are constitutional in nature. The laws of the parliament does not transgress their power. Now these very powers are called as number 1, absolute veto, where the president says that I am not going to pass this very bill. It was practiced by Dr. Rajendra Prasad in 1954 because at that time the house was dissolved. Similarly, there happens to be suspensive veto. If not the money bill, the president has power to return the bill back. Once the bill is sent back to the president has to accept it. This was practiced just one in 2007. Similarly, when it comes to qualified veto is not with the Indian president, it is with the US president, where the bill of the president can be overridden by the majority of the Senate. And the last one happens to be the pocket veto used once, in which the president can just stay quiet, keep the bill in the pocket and relax. So these kinds of powers have been granted to the president. The same powers are with the governor of the states as well. So these powers can also be used by the governor. Now when it comes to the governor of the bill, the governor of the state, what governor can do? Governor also has these 3 powers apart from the 4th power. Now this was the news. The news was that governor of Kerala or the governor of Tamil Nadu is unnecessarily stopping the bill without any reason. So why is it so? When it comes to the concept of pocket veto, the pocket veto in India does not follow the rule of constitutional punctuality. Now what is this constitutional punctuality? Let us say when it comes to pocket veto, does constitution mentions any time frame for a pocket veto? Let us say the president or the governor is stopping the bill or pocket vetoing the bill. Is there any time frame that for this much time they can stop the bill, for this much time they can keep the bill with them? Answer is no, there is no time frame. Whereas in USA, the pocket veto is only for 10 days. The maximum amount a bill can be withheld with the president is 10 days. And this is where the court has to come forward. The court gave a judgment that these powers should follow the concept of constitutional punctuality. Constitutional punctuality is a very important feature over here. It has to be followed by the various governors. Now, when it comes to the powers of the governor, obviously, the governor also has the same power. The governor can assent the bill. The governor can withhold the assent. The governor can return the bill and at the same time can reserve the bill for the president. If any bill of the state tries to trespass the powers of the center or any state bill is not as per the constitutional mandate, then the governor has a discretion. It is called as a constitutional discretion. Why it is constitutional discretion? Because over here the governor need not discuss the council of ministers. He can on his own stop the bill and keep it for the presidential consideration. Now, when under Article 201 the bill is given to the president, president may assent it, president may withhold the assent, and president may ask the governor to return the bill. Now again the question comes, for how much time this can happen? When it comes to the pocket veto of president on his own, when it comes to the pocket veto of governor on his own, then this is a limited power. That means you can, when it comes to returning back, when it comes to suspensive veto, then there is a limited power. What kind of limited power? That you can send it once the bill is back, you have to assent it. Whereas over here, the president can return the bill as many times as he want. So this was the judgment recently, that a timeline has to be given. The president was asked, it was prescribed that president is also required to take a decision with regard to the reserving of the bills. So you cannot keep a bill for more than 3 months. This is what has been given by the Supreme Court of India. So whenever a bill has been presented to the governor, the governor will keep this bill, may keep this bill for the presidential assent or for the presidential consideration, and president has to resolve this bill in almost 3 months, not more than 3 months, shall be taken by the president. Okay. Similarly, in case of governor also need not pocket veto it for more than 1 month. Governor should not pocket veto it for more than 1 month. So these are the changes which have been prescribed by the Supreme Court of India. Next comes the pardoning power. They are also always in news. Now what exactly is pardoning power? Pardoning power means if someone has been convicted by the court, so principle of natural justice says that the person shall be given. The person shall be given a chance of reconsideration. So before starting that, let us quickly see judicial powers. What are the judicial powers of president? Appointment of the chief justice, then and the judges of the Supreme Court and High Court, and then seeking advice from the Supreme Court under Article 143, granting pardon, reprieve, respite and remission. Now coming back, that the president has been given certain powers. Now what are these powers? Powers are power to pardon. Pardon means, let us say the person has been convicted of any offense. So once given the pardon, that all the offenses would be absolved. He would be absolved of all the offenses, all the FIRs against him, all the judgments against him has to be absolved. Next, respite, where a lesser sentence is given. In case of a special circumstances, let us say a person that there is a female who is pregnant or an old age person can seek for respite. Then similarly, reprieve, then whenever there is a death penalty, if death penalty has been awarded, the president can first reprieve. Reprieve means temporary suspension of the penalty till the time the final decision is taken on his pardon application, mercy clemency application. So then till then reprieve has to be done. Next, remit, reduce the period of the sentence. Let us say it was earlier 10 years, it would be reduced to 5 years with no change in the character. And commutation means giving a lighter punishment. Earlier it was a stringent punishment or solitary confinement. Now it would be a lighter punishment. Now in 𝐂𝐻 Singh case, no judicial review for the bona fide, but yes, when it comes to the mala fide, judicial review can happen. So let us say If the president uses Article 72, similarly governor uses Article 161, over here judicial review is, the constitution says that judicial review is not possible, but the court has said yes, it is possible if the given advice is the of malified nature. Similarly, it is the discretionary power of the president. One more thing, seeking pardon is not your right. Pardon is not right. Neither it is duty of president nor duty of president. Neither your right nor duty. Neither right nor duty. So this is where president can keep these applications pending for as much time as they want. Next comes Article 161. The same power is given to the governor. Yes, there are material differences. We'll just discuss that. That governor cannot exercise this power in case of death sentence and court martial. Now there is another word usually used, amnesty. If you could recall, recently amnesty was given to Julian Assange. Now what exactly is amnesty? Amnesty is usually given for the political crimes. So pardon is only for the criminal offences, whereas amnesty for the political offences. Article 72 doesn't give amnesty, it only gives pardon. The person who is convicted of some crime shall be absolved or shall be given pardon in that crime. Okay, no time frame for disposal. Obviously, we can see that in the case of Dhananjay Chatterjee, he filed a petition in 1994 and it got resolved in 2007, 2004, 2005. So it depends upon the president to president, it depends upon the government to government whether they are interested in disposing of these applications or not. Then president has to act on the advice of Council of Ministers. Council of Ministers advice remain very much important over here. The president has to take the Council of Ministers advice. President cannot dispose these applications on their own. Same happens with the governor. Foreigners also have right to seek pardon. They can also seek pardon over here. Now next comes the mercy petition. So we have just discussed this topic. Let us see what exactly is mercy petition. That means, let us say if anyone's death has been confirmed by the court, and in that scenario the person can go to the President of India. In case of death only, mercy petition can be sought. The death sentence convict has an option to appeal to the Supreme Court. Yes, if the Supreme Court also says that no, that the judgment of the High Court is correct, you shall be hanged, you should be hanged till death. In that case, the person can go to the President of India under Article 72. What is the exact ground of appeal? So the person concerned, what he need to do, he need to basically first present a ground why he need a pardon. Grounds can be that a person is only bread earner of the family, he is not physically fit, he is a female, is a pregnant female. In that scenario, or the punishment given to him is very harsh. In that scenario, the person can move to the court saying that he needs a mercy petition, she needs a mercy petition. Now Supreme Court in 𝐂𝐻𝐍𝐃 case has said that this is an act of grace, this cannot be claimed as a right. So it is purely an act of grace. You can just file the petition, you cannot force the president to dispose of, and president is not duty bound at all. Now let us say if you want to exercise this constitutional provision, how you are going to exercise this. Okay, so exercise of this particular provision can be done through the jail superintendent. The person will file the petition to the jail superintendent. The jail superintendent will submit it to the President of India. The President of India will submit it to the cabinet, and depending upon the advice of the cabinet, the Home Ministry will do all the checks. Home Ministry will examine. Home Ministry will finally give the recommendations to the President, and as per the recommendation, the President is going to act. Though there is no written procedure in the Constitution, there can be a question: is there any written procedure in the Constitution? No written procedure in the Constitution about this very idea. Now coming back to the topic, why we need this? We have already discussed that why we need this: to ensure principle of natural justice. They can ask, Article 72 is related to which of the following? 72 is related to the principle of natural justice. Does president has to follow any law over here? Any criminal law? No law has to be followed. Only method is that the president has to follow principle of natural justice. There has been a grave miscarriage of justice, and the president is going to help now. Okay. Now let us compare the powers of the president quickly. President, governor, 72, 161. Now In which cases president can use this against union laws? In which cases governor can use this against state laws? Under military court or court martial, it is allowed, does not extend to court martial at all. For president, death sentence is allowed. For governor, death sentence is not allowed. That means governor cannot use this power in death sentence and court martial. Next comes pardon, completely absolves, commutation, remission. This we have already discussed. Now, what exactly is the scope of authority? Obviously, when it comes to the president, the laws of parliament, court martial is included. Over here, it is only limited to the state laws. Advisory role, yes, in both the cases, council of ministers are involved. In case of death penalty, president can but cannot, governor cannot. This we have already discussed. Now, there are other terms involved with these mercy petitions. One is review petition. What exactly is review petition? Review petition happens in court only. Let us say if the court has given a final judgment, the person involved, the convict, can file a review petition. In review petition, the same bench will sit. The same bench will sit and discuss the matter and will give the judgment. So, as you know, the same bench is involved. So, chances are very less. Chances are very less that that something new will come up. Obviously, the same judgment might be repeated. Whereas curative petition, it all started in 2002 by Rupa Ashok Hurra case. Over here, the court allowed the curative petition. In this, if you think that justice has not been served, you can ask for a cure. So first, the person has to file a review petition. Then he goes for a curative petition. In curative petition, new bench is constituted and the case is rejudged. So over here, case would be rejudged. But again, the problem is that the chances are very low. Obviously, more than this, but low. And then finally, if nothing happens, nothing works, go and file a mercy petition. Next, there is another term called parole. What exactly is parole? Look, parole is nothing but a temporary break from the jail. So parole is nothing but suspension for a temporary time. Release is conditional. A person who has to go outside should have a reason to go outside. Let us say parole is being sought. So the person should have a reason that why he wants to go on parole. So parole is again a kind of a reformative process. And in fact, there is another process called as furlough. So furlough is just ahead of parole. What exactly is furlough? Furlough means that remission of the particular sentence. If the furlough is being given, so that means the person need not serve the additional terms or the given tenure. Let us say a person was convicted for 10 years. He has completed 6 years in the prison. He can ask for a furlough. And if the furlough is granted, then the person need not return to jail. He can now spend his life outside. His remaining 4 years have been waived off on one condition, that he should not get involved in crime again. Parole means that those remaining 4 years have not been waived off. The person will go out. He has to come back. He has to serve the jail. Now the question is that who is responsible for these kinds of parole and furlough? Parole and furlough are guided by the state laws, because when it comes to jail, when it comes to prison is regulated by the state government's laws. So state government is responsible for management of prisons, and obviously the people are kept in prisons only. So state government's laws on parole and furlough applies. It varies from state to state. So it is not possible to discuss every matter over here, because every state has their own ways of granting parole. In fact, many times furlough word is not given, parole word is equivalent to furlough. So don't get confused that we have read the parole somewhere, we have not read furlough, or what you are telling is parole only, not furlough. So there are very similarities in the practice of these kinds of words. Now next topic is money bill. Money bill again was always in news. Why I have brought this slide? Because every time students ask, can money bill be passed by a private member? Yes, private member can introduce money bill. But the problem is, in a month back, I recorded a video, we uploaded a video in which we have discussed what is private member bill. We have seen that private member bills are rarely passed. The last bill passed was in 1970s. Okay, till date 14 bills have been passed, and rest of the bill have failed to be discussed or to have to come on the floor of the house. Now when it comes to money bill, Lok Sabha has power. Why Lok Sabha has power? Because Lok Sabha is represented directly responsible to the people. Lok Sabha is the keeper of the public purse. It protects our money. So that is why they have the power. Rajya Sabha doesn't have the power. So let us quickly recap. Certifies money bill. Certification cannot be questioned in court of parliament. Many times the matter has been raised whether the bill introduced is money bill or not. In separate ways, the Supreme Court has given the judgment. But there is one case, famous case, Raja Rampal case of 2007, in which the court has categorically said that we will not question the procedural irregularities, or we will not question the procedure of the parliament. So certifying what bill as a money bill is the pure procedure of parliament. And article 122 says that, 121, 122 both says that court will not interfere in the parliamentary proceedings. Parliament will not interfere in the court ongoing subjudice matters. Now, Rajya Sabha cannot amend or reject, may return the money bill. Recommendations can be accepted or rejected by Lok Sabha. Maximum period for passage of this bill is 14 days. Can approve, President can approve or reject but cannot return. Joint sitting for money bill is again not possible. Why? Because there is no provision of deadlock. Unless there is a deadlock, there is no joint sitting. Article 108 of the Constitution talks about joint sitting. Joint sitting will only be done in case of ordinary bill, neither money bill nor constitutional bill. Why? In money bill, Rajya Sabha has no power. When no power means no deadlock. And in constitutional amendment bill, you need special majority. And joint sittings the bills in the joint sittings are passed by the simple majority. Now there is another confusion with the students most of the time. Then what exactly is financial bill? Usually we write finance bill, but what exactly is financial bill? Look, there are two kinds of bills. First, we discussed ordinary bills, which are dealing with the ordinary legislation. Then we have the money bills, which deals with the money function given under Article 110 of the Constitution. Now, what exactly are finance bills then? These are the culmination or the mixture of ordinary and money. Any bill having more finance functions and more money functions, less ordinary functions would be termed as Financial Bill 117 Clause 1. Any bill having more ordinary functions and less financial functions would be considered as a ordinary bill with financial functions. Let us say, for example, if the government has created any new, let us say the government has created some 5G law has been implemented. It talks about a 5G fund. To fund this 5G fund, the government would take money from Consolidated Fund of India. But the major law was of ordinary function, telecommunication bill. In telecommunication bill, they are constituting a 5G fund to promote 5G infrastructure. The primary function is though ordinary in nature, but without this fund, this particular law will not be able to operate. So that would be Financial Bill 1. Let us say if the government wants to, there was a bill recently, the government wants to add more tribes into ST list. So for adding more tribes into ST list, there would be some kind of expenditure. The money has to be taken out of the Consolidated Fund of India. But our major purpose over here is not taking the money out. Major purpose is giving the ST status. So here the prime objective is adding more tribes in the ST status, and obviously there would be an expenditure thereof. So this is where it would be called as Financial Bill Type 2. Now let us see what are the different powers with regard to them. Definition, provisions of Article 110 and other provisions obviously looks like a money bill, has more features of money bill, but yes, a part of ordinary bill as well. Does not include any provisions of Article 110, but only involves the expenditure. Can be introduced in Lok Sabha, can be introduced in either house of parliament. The one which is more closer to money, Finance Bill 1. President recommendation usually required during the consideration stage when the bill is in the on the floor of the house. Procedure, same parliamentary procedure. It is nothing but an ordinary bill in terms of treatment. Role of joint session, if two houses disagree, joint session is possible. Joint session is applicable like ordinary bill. It is more like ordinary bill. It is more like money bill. Here Lok Sabha has more power. It is almost same as the Rajya Sabha, as the ordinary bill. President can approve, withhold, return. Same unique features, only originates in Lok Sabha, can be originated in the any house. So this is the major difference. Now moving ahead, another thing which was in news was preamble. Now what exactly do you understand by the term preamble? Preamble means the preface of the constitution. There was a long debate with regard to the preamble, what is to be done with the preamble, whether preamble is the part of the constitution or not. So ultimately in Keshavan Bharti case, it was decided that yes, preamble is the part of the constitution. So preamble is part of the constitution. It is part of the constitution. Okay. What next? Does it grant power to the parliament? No, it is the guiding light. Guiding light. Next is, can it be invoked or can you go to court? Is it justiciable? No. Can't go to court. Okay. Now, what was the news? The news was that there was a petition filed in the court in which the words socialist and secular were asked to be removed. The petition said that socialist and secular were not the part of the original constitution, hence they should be removed. Then what exactly was the part of original constitution? Original constitution was derived from objective resolution of Nehru in 1946. It originally consisted of a sovereign, independent republic. But by the time we drafted constitution, preamble was the last paper to be written, to be added in the constitution. We were already independent. So we removed the word independent and put up sovereign democratic republic. Similarly, the term fraternity was also not part of the objective resolution. It was never ever discussed in the major meetings of the Constituent Assembly. Then what made us to put the word the fraternity over here? Because after 3rd of March 1947, riots broke in the country, and this is where till 1948 there was a lot of crisis between Hindus and Muslims, and this is where the assembly thought, let us add the word sovereignty as well. Similarly, unity was there, integrity was added later on. So this very preamble was first and the only time amended by 42nd amendment, in which the words secular, socialist, secular and the word integrity was added. Okay, fine, sorry, this one, integrity was added. Done. Next topic is rights. So what are rights? Rights are nothing but entitlements. Rights also have correlative duties. In most of the cases, you will get your right once you will do your duty. So right is correlative to duty. This is very essential. Then what are rights? Rights are entitlements. They will perform positive, usually they are there to perform positive functions. What are the positive functions? That let us say you would be given the life, liberty, security, food, etc. In fact, many times it also asks the state not to perform something. So we can say that rights are both positive. Rights can be categorized into two parts: the negative rights, the positive rights. Negative means state shall not state shall not. Positive means state to take actions to ensure benefits. Here, right to life. Here we have reservation. Here we have reservation. So life, reservation. Done. Next, rights can be enjoyed by citizens or persons. We know that there are many rights, we have discussed in earlier videos as well. There are many rights which are available only to the persons and very few. Article number 15, article number 16, 19, 29 and 30 are only applicable to the citizens. Next, are rights absolute? There can be a question. Rights are never absolute. Privileges are absolute. What is the difference between privileges and rights? Rights comes with restrictions. So you can say privileges, rights plus restrictions, rights minus restrictions equals to privileges. So when you will remove restrictions from the rights, it will become privileges. Privileges means do whatever you want to do. No one is going to stop you. Rights means do whatever you want to do, but as per the given law, as per the given frame. So this is where rights always comes up with restrictions. Why? Because one's right, if someone is enjoying their right, the person might interfere into others' rights. So that is why this restriction has been categorically demarcated. Then what are the types of rights? Again, natural rights. Natural right, it all started with the writings of John Locke, in which he said that life, liberty and property are three essential rights. These are inalienable rights. Alienable means rights cannot be taken away. You cannot take away these rights from anyone. They are inalienable rights. Whereas when it comes to human rights, it all started with Universal Declaration of Human Rights 1948, where the United Nations come up with a Charter of Human Rights in which the rights were demarcated. Done. Next comes fundamental rights. Obviously, rights. What are the fundamental rights? Rights which have been given in Part 3 of the Constitution are called as fundamental rights. Okay. Then UDHR. Let us quickly see what kind of rights have been given in UDHR. Usually there was a question in which the UPSC asked which of the following consists of fundamental duties. So people were not aware of the fact that UDHR also consists of some kind of duty. So quickly let us do a recap of UDHR. Equal right, right to be equal, right against discrimination, right to live in freedom and safety, right against slavery, right against torture, to be treated equally, equal protection of law, justice, no unfair treatment, then right to public hearing, right to be proven innocent until proven guilty, right to remain innocent until proven guilty, then right to privacy. It is already a fundamental, it's already a human right. We also have this as a fundamental right, right to be free, right to have protection from persecution, right to belong to a country. That means a person cannot be sent out of a country. If that means a person cannot be made citizenshipless. So everyone should have a citizenship at the given point of time. No one should in the world should be without any citizenship. He should or she should have citizenship of any one country in the world. Next is right to own things, right to have our own thoughts and religion. This is again we have in our constitution. Then right to think and say what we want, Then right to gather peacefully, right to take part in government elections, right to a social safety net, right to work, join trade unions, right to play, right to health, right to education, arts and science, right to enjoy free and fair elections, free and fair, right, we have a responsibility towards community. This is your duty. When you have a responsibility towards community. So right number 29 is a duty over here where a person has a responsibility towards a community. And obviously no one can take away the fundamental rights. Next, there was a news of right to residence. Delhi High Court recently ruled that foreigners cannot claim right to residence, despite of the fact that Article 19 only applies to the citizens. So here the person coming from outside cannot demand a residence. Next, we have already discussed this, fundamental rights available to all. This we have discussed in other videos as well. Fundamental rights available not available to foreigners. Habeas corpus is also has been discussed. Right to be free from adverse climate change. This is again a fundamental right under article number 21. Right to health, again 21, also consists of right to health. So there can be a question on article 21 that which of the following rights fall under right to life. Next comes DPSP, that environmental protection is also a DPSP 48A. Then 51G, it is also a duty that every citizen of India to protect and improve the natural environment including forests, lakes, rivers, wildlife, etc. Next comes custodial death. Now in the D.K. Basu case, the court said that custodial death is against right to life. If the person has been put up under custody, if he is under some kind of custody, whether in police or in jail, in whatsoever custody it is, in that scenario, if that person dies, that is the infringement of article number 21, because right to article 21 says that right to life. So let us discuss about this very idea of custodial death. What is police custody? Someone is in police, let us say post arrest, the police can keep the custody of a person, of the accused, so that the police can investigate, interrogate. What is judicial custody? If the person has been sent to the jail, jails are managed by the state governments. Person living in jail is a judicial custody, person living in police lockup is a locked up in a police lockup is a police custody. Then again, this we have already discussed. Okay. Now, when it comes to the various provisions involved, if they ask a question, which of the following provisions are involved? Which of the following provisions are involved with regard to the custody? So, Article 21 of the Constitution, right to life, personal liberty. It includes protection from torture. Then you have CRPC sections. Then you have Indian Evidence Act. Again, custodial death, NHRC guidelines, no custodial death, SC rulings. 10 points were laid down for arrest and detention. That the person when the police is arresting someone, police need to take following measures. What are the measures? A diary entry has to be done. The person should be told his right against right to remain silent. Then a legal recourse has to be given to him, to be taken to the nearest judicial magistrate within 24 hours. Constitution also says it. Then the person should be taken to a medical should be conducted. Then in the arrest, no violence should happen. He should be allowed to meet. Then obviously post release, the medical again should be conducted. So these are various provisions. Now when it comes to the torture, India has already signed the Convention of Torture, United Convention, but has not ratified it. So once we will ratify it, we also have to remove death penalty. So the Convention on Torture, United Nations Convention on Torture also says that the countries will not use any kind of torturous punishment or punishment which consists of torture. So again, death penalty is also part of torture only. Next, types of will, this we have discussed in the other video. Next comes right to be forgotten. Now, what exactly is right to be forgotten? As you know that in this the tech industry, in this social media world, many times our videos get leaked, or the videos are uploaded, or our actions are uploaded, and the people get criticized for those actions. So this is where a person who happened to be a convict, who happened to be an accused at one point of time, he wanted that his videos should be removed, and this is where went to the he went to the court and asked for right to be forgotten, that I want my videos to be deleted, I should be forgotten from this very internet. Okay, and Delhi High Court said that right to be forgotten is a fundamental right under Article 21. But Supreme Court has not said anything till now. So right to be forgotten is a fundamental right. Okay. Now, next comes Speaker's power to accept resignation. This was again in news. What exactly is the problem over here? Article 101 of the Constitution says that the Speaker, Chairman, okay, would accept, or the MPs would resign to the Speaker or Chairman. Let us say if any MP or the chair, or if any MP has gone to the Chairman, went to the Chairman while submitting his resignation, the Speaker or Chairman can withhold the resignation as per the powers given to them by 33rd Amendment. Now, what does 33rd Amendment says? 33rd Amendment, brought in 1971-72, was nothing but it gave more power to the Speaker or Chairman to reject and return the resignation of the MP on the grounds of involuntary resignation or non-genuine resignation. So, if the Speaker finds that the Member of Parliament's resignation is not genuine, involuntary, in that case, this resignation can be rejected. Okay. But the court has time and again questioned this particular amendment. Court says that the MPs should have a freedom, a free way of giving resignation. Their resignation should not be curtailed, it should not be rejected. If any member of parliament wants to resign from their seat, she should be immediately allowed. The speaker should not have the ultimate discretion. So ultimate powers under Article 101 is with the Speaker, Chairman of the House, that whether you would or you would not, you can deny or you can accept the resignation. If they deny the resignation, that means the person involved would not be able to give resignation. Okay, just make this, keep this in mind. There can be a question on this. Next comes cabinet committees. Now, recently, the ruling party Lok Sabha will retain the control of key portfolios of home, defense, finance, and external affairs cabinet committees. Obviously, 77 says that for the smooth conduct of the union government, the distribution of work can be done. Accordingly, the president has issued certain rules, that allocations of the rules has been given to the government and transactions of the business rules. So this is where the Prime Minister has got the power to come up with certain committees. Now, what are these committees? These committees are extra constitutional body. That means they are not part of the constitution. They are not written anywhere in the constitution. So who establishes the cabinet committees I am talking about? The cabinet committees are established by the government of India only. So as per the needs and demands. These are again two kinds of committees, the ad hoc committees or the standing committees, depending upon the need and necessity of the committee. Committee of Finance, Cabinet Committee on Finance, Cabinet Committee on Defense, these kinds of committee would be standing, and rest other committees can become ad hoc in nature. Now, membership is basically from 3 to 8 members. Non-cabinet ministers are not excluded from participation. So that means if you are a non-cabinet minister, so technically again you can sit in those discussions. Okay, it depends upon the government only. So this is where the news has come, that government has taken the control of the Home, Defense, Finance and External Affairs Committee. All the members in this are from the ministers, are from the government only. Another is pro tem speaker. Now the constitution says that the speaker may resign, or the speaker may resign to the deputy speaker. So as and when the speaker wants, he may resign to the deputy speaker. Okay. But what happens when the speaker completes his tenure? Let us say the House has completed its tenure. The House has completed its tenure. Now every member has to go, but speaker has been given this exclusive power that he will remain on the post till the first meeting of the next Lok Sabha. Recently 18th Lok Sabha was constituted. So there were the person, basically Mr. Om Birla ji, was having this power, or he was allowed by the constitution that he can continue in the next particular session, first day, for as a pro tem speaker. So what is pro tem speaker? Pro tem speaker is nothing but a person who is allowed to preside the first sitting of the houses. The reason is, as you know, all the members are new. In the 18th Lok Sabha, new members would have joined. When new members would have joined, so none of the member must have taken the oath. Without taking the oath, the member would not be allowed to sit in the house, will not be able to vote. So there should be someone who should ensure the oath. Technically, the constitution says that who is responsible for the oath of MPs? President is responsible, but president cannot ensure the oath of every other person, every MP. Though president is directly involved in the oath taking process of ministers, but when it comes to other MPs, president is usually not involved. So president has given that task to the speaker. So now what shall be the task of this person? The constitution doesn't use the term pro tem. It only says that the current speaker would continue till the first session of the next Lok Sabha, first sitting of the next Lok Sabha. What he does? He presides the first sitting, administers the oath, conducts the floor test, and holds the election of the speaker and deputy speaker. So once speaker and deputy speaker are elected, they come to the house. This is where the pro tem speaker then immediately resigns. So currently who appoints pro tem speaker? Either the previous speaker continues as a pro tem speaker. If previous speaker is not willing to, if previous speaker is not available, then the president usually appoints any senior member, the most senior member usually. This is not written anywhere. This is part of practice convention. The most senior member. Here the most senior member is given this task of joining the as a pro tem speaker. Now next office is governor's office. What exactly are the powers with the governor's office? First is, if you will see that governor happens to be the linchpin of the system. He is a very important person who is responsible for maintaining or the coordination between center and state. So he is nothing but a linchpin of the administrative system, of the government system, who ensures a connection between center and state. From where have we got this office? If you see the Government of India Act 1878, it first time transferred the powers to from company to the British Crown, and governors were made the agents of the Crown. In fact, they used to work through Governor General. Then after that, Montagu-Chelmsford reforms came. In that, they introduced minor changes and they implemented the responsibility of these people who would be taking care of the provincial governments. Then finally, Government of India Act granted provincial autonomy, and they ensured that a governor has to be there, and the governor need to act on the advice of the Council of Ministers. This is what has been implemented in our constitution as well with regard to the president, and similarly with regard to the governor. So president under Article 74 has to abide the Council of Ministers advice. Similarly, 163, governor has to abide. And this is what we are continuing till date. Next, the question is, topic is appointment of governor in states. Now, Article 153 says that the governor shall be there. 152, 151, 153. There shall be the governor. 153. There shall be the governor. Now, what does the governor? Yeah, what exactly would be the qualification of the governor? Eligibility of the governor? Citizen of India, 35 years of age minimum. Now, next comes, who shall appoint the governor? The president shall appoint the governor. What shall be the term, tenure of governor? Tenure would be 5 years, but at the same time, the governor shall work on the pleasure of president. So, pleasure of president is again very important thing over here. Either pleasure or 5 years, one thing will work. Next is, the governor would come with warrant and seal and ensure that the decisions of the center are implemented, or the work given to him as per the constitution is done in the states. What is his role? As a coordination agency. What, he is also the part of the legislature, state legislature. So, governor plus state legislature together passes the bill. Any bill which comes to the governor can be assented, may be assented, may not be assented, and depending upon the assent, the bill becomes the law. Now, does every state require one governor? Yes. Does every state require individual governor? No. There can be one governor, one person who is governor of two or more states. There can be a person who is governor of one state and lieutenant governor of one state. In case if a person is serving two states, the salary would be adequately decided and divided among the states. Next, here comes the powers. Now, governor has certain powers over here. What kind of powers they have? There are technically two kinds of power given to the governor or the president. The power can be constitutional power or constitutional discretion. Put it discretionary powers. What are discretionary powers? Powers which I enjoy as per the discretion. Constitutional discretion. Another comes the situational discretion. The constitutional discretion and situational discretion. Now, what exactly the term constitutional discretion means? The constitutional discretion means if something is written in the constitution, yet I have a discretion to go my way. Despite of something written in the constitution, I can do it my way. Situation means as per the situation I will decide. There is no written format for that. Now the question can be, who among the following, governor or president, among the following has both the powers? So governor has the constitutional power. Governor has the constitutional power. Governor also has the situational power. So governor has both constitutional as well as situational power over here. Fine. Whereas when it comes to the president, president only has situational discretion. President does not have the constitutional discretion, because every time the president has to act as per advice of Council of Ministers. So president will always act as per the advice of Council of Ministers. Now let us see. Governor, what are the constitutional discretions of governor? Governor can reserve any bill. Okay. Though usually it is believed that governor can only reserve those bills which are against the center's power, but no, governor, if finds that any bill is against the constitution, governor can always reserve that bill for the president. So presidential consideration, who will decide? Governor will by himself decide. Then governor can recommend 356. Article 356 says that on the report of governor, the president may invoke the president rule. Constitutional breakdown of machinery can happen on the advice of governor. So governor's advice. Who will guide governor to give this advice? No one. Can governor on his own uses this power? Yes. Is there any format? Is there any prerequisite condition? No. Whenever governor feels, if governor feels today the things are not right, he may write to the center or the president that Madam President kindly invoke 356, situation is not right here, there is a constitutional breakdown of machinery. So acting as administrator of UTs, when the governor is administrator of UTs, no one can question his constitutional powers. Similarly, seeking information from chief minister and determining the royalties for the councils in Assam, Meghalaya, etc. Okay, about the 6th schedule. Now, when it comes to the situational discretion is with both the governor, it is with the president as well. As per the situation, if there is no sitting council of minister, if the PM has resigned, CM has resigned, CM has died, in that scenario, there is no government in the house, the governor and the president both have the power to decide the next course of action. Who shall be the CM, who shall be the PM, whether new elections are to be constituted, house is to be dissolved, what should be done, is the pure discretion of both governor and president. Okay. Next comes motion of thanks. Article 87 says that it is the duty of president, and similarly there is a duty of the governor as well under Article 176. Now, what exactly these articles are about? They say that during first sitting of new house, new Lok Sabha, or during first session of new year. First session of new year. In both the cases, the president or governor can give a special address to house jointly. Okay. House, Rajya Sabha, Lok Sabha. Now, what does special address consist of? What exactly is this special address? Special address is about the achievements of government, previous government or the current government, and future prospects. Either what has happened or what is going to happen. What the government has done so far, what the government shall be doing. So this is where either the achievements or the future prospects have to be given, have to be conducted. Number one. Number two is this very speech is submitted by the Council of Ministers. Okay. The governor and the president has to follow this. Cannot skip thus or cannot change the format. Format cannot be changed. So they cannot change the format of the speech. So special cannot change the format of the speech. What next? Cannot skip anything. So whatever paper has been given to the president, the governor, they have to follow it. Done. Now what next? Once the address is done, the address would be passed. There would be a motion of thanks. Now House will give motion of thanks to the president governor. Under this motion of thanks, the opposition can ask for an amendment. They may say that, madam, this was wrong, this statement was wrong, this is partially correct, this is false. So that amendment can be sought. Over here, if the opposition is able to stop this motion of thanks, that means the opposition has good amount of numbers, if they have good numbers in the house, and immediately they can bring no confidence motion. So it is believed that failure to pass motion of thanks may result into no confidence motion, and obviously when no confidence motion comes, the government has to resign. Okay. So 87 says that motion of thanks, parliamentary procedure in which formal motion is presented to express gratitude. 87, President addresses both the houses. Purpose, informs Parliament about the summon, why it has been summoned. Annual feature, it is an annual feature, it's a special address. Then amendments can be moved by the opposition, then put to vote in the House. If opposition if opposition would be able to implement the changes, that means opposition is strong enough to remove the government. Next comes dissolution of the Standing Committee of Statistics. Now, what exactly this committee is all about? So, Union Ministry of Statistics dissolved this very committee. So, this committee was chaired by a renowned economist. It was formed to recommend the improvements in the economic data and surveys, how we have to change the statistical things, and then ultimately the steering committee replaces the National Statistical Commission. So, this committee replaces the SCOC and is headed by the National Statistical Commission chairman. Composition was 17 members and 1 member secretary. Tenure was 2 years. So, this is very factual. You can just go through the slide. Next comes federalism. What exactly is federalism? The term federalism comes from the term contract. Federalism means division of powers. Powers which were at the one unit, few of the powers have been given to the other unit. This is called as a contract. So we are again a quasi-federal nation. Why? Neither we are unitary like Britain, nor we are federal like US. So we are in between them. We are a quasi-federal. Our model is union tilted model. So we are not the union of, we are the union of states. We are not the United States. Okay. So India, that is the union. Okay. Over here, most of the powers are with the center. Important powers. Now, what kind of powers? Article 1, Union of States. That means no state has power to secede. Union means we follow the concept of the holding together federalism. It is holding together, that all the states have come together and now state is holding them. State is not allowing them to go away. Whereas US is coming together. US is coming together. So we are a indestructible union of destructible states. States can be destructed. Article 3 says that Parliament has power to change the territory, rename the state, divide the state, add the state. So we are indestructible union of indestructible states. On the other hand, US is indestructible union of indestructible states. Neither union nor states can be changed over there. Next, the term federation is not explicitly mentioned in the constitution. Article 246 talks about the division of powers. We have created Schedule 7. Schedule 7 consists of 3 lists, the union list, the state list and the concurrent list. Union list, union has power. State list, both have power. State has power. Concurrent list, both have power. But whenever a law of union and a law of state has been passed as per the concurrent list, the law of union would prevail. At the same time, Article 248 also talks about residuary powers. Now, what are the residuary powers? Residuary powers are those powers which means that if no particular power has been assigned to anyone, let us say no power has been written in center, state or concurrent, union, state and concurrent. There is no power written in either list. Then who will be able to use that power? In that scenario, union would be able to use that power. Entry number 97 of union list says that residuary power lies with union. In US, residuary powers lies with state. In true federal nations, residuary powers is always with the state. In semi-federal nations, residuary power would be always with the union or center. Then 249, here the Rajya Sabha has power. The legislation of the Rajya Sabha will remain in force for 1 year. This we already discussed. Then 256, it requires the state to comply with the laws made by the parliament. Obviously, here the center can give directions to the state to follow certain provisions, and if state fails to follow certain provisions, then obviously we have article number 365 and then 356. We'll discuss this. Then 263 talks about establishment of interstate council. So interstate councils have been established. Interstate Council was first established after the recommendation of Sarkaria Commission. Interstate Council is a constitutional body then constituted by the President. The problem is that Interstate Council doesn't work or it hardly meets. So when there are very less meetings of the Interstate Council, so again the problem comes that this organization is not fully functional. 275 grant in aid to the state. Then you have 279A empowers president to the constitution to constitute a GST council by 101st amendment. Then you have 356. Now what exactly is 356? 356 nothing but constitutional breakdown of machinery. If the situation arises, if the situation arises, what exactly is the situation? That there is constitutional breakdown of machinery. Is it mentioned anywhere? Not defined. What is constitutional breakdown? Not defined. So what happens over here? The government, the legislature is suspended. Suspension of legislature. First thing is suspension of legislature. What next? The powers of the assembly goes into the parliament. Now parliament takes control, legislative functions. Okay. How it is implemented? Either on report of governor or president by herself or himself can invoke article number 356. Okay. So the constitution says that on the report of the governor or otherwise. What is otherwise? Otherwise means, okay, the president on their own can do this. Now what happens? Once the 356 has been invoked, the resolution of this 356 is kept in the house within 2 months. So time frame we have that within 2 months you have to keep it in the house. The house will pass it through simple majority. How it is removed? Shall be removed by a subsequent proclamation. If situation is fine, situation is right, then the president may withdraw it. What exactly is the total duration? Total duration is 3 years, but again in every 6 months a review has to take place. Then comes grants the parliament. Article 368, it grants the parliament to amend the constitution. There are 3 kinds of amendments which can be done in the constitution. One is the amendment for FR, for DPSP, FDs. These can be done through the special majority. Then you have various other kinds of amendments like amendment to the Citizenship Act or amendments to the unitary features of the constitution. Amendments to the unitary features, they are done by the simple majority of parliament. I'll just add one thing. Article 3. If parliament has to change the area of any state, if a parliament has to bifurcate a state, divide a state, add the state, which kind of amendment? Simple. If parliament has to acquire a state, add the territory, simple. But if you have to subtract the territory, give away some territory to other, then it has to be through special majority, special plus state's ratification. Okay, this was done in 100th amendment. And then you have the pure federal features where states are involved, like High Court powers, amending Schedule 7 of the Constitution. Here special majority plus half, more than half of the state's ratification. Ratification. Done. Next comes seventh schedule. Again, seventh schedule talks about the various list. This we have already discussed. Fifth schedule and sixth schedule. Now there are different schedules to the constitution. What exactly these schedules have? Fifth schedule is with the non-sixth schedule areas. It is with the non-sixth schedule areas. Now what exactly are the non-sixth schedule areas? First, let us look towards the sixth schedule areas. Okay, the areas of the Mizoram, Tripura, Assam, as well as Meghalaya. So these four states have the sixth schedule status. Now, when it comes to sixth schedule status, these six schedule states have autonomous district councils. So that means their panchayats are the most powerful panchayats. They have administrative, legislative and financial powers. On the other hand, the rest of the nation is covered through fifth schedule status. When it comes to the fifth schedule, then again the president has power to demarcate any area or to increase or decrease any area with the consultation of governor. Whereas fifth schedule can be created again through the constitution. Then powers are taken from the legislature, they are taken from the constitution. Powers are limited in nature. Sixth schedule powers are limited in nature, very limited powers, no legislative or judicial powers. Here you have executive, legislative and financial powers, broad powers. Then delegation of powers decided by the state governments. Here you have already a broad list of powers. Then state executive power extend to schedule areas. Any law of the parliament will automatically apply to fifth schedule if not stopped. Any law of the parliament will not apply to sixth schedule unless asked for. So this is a basic difference between two. That this is a weak system, this is very strong system. No powers to levy taxes. Here you have power to mobilize funds. Budget preparation not allowed. Source of income not mentioned. How the parliaments would be earning, it is mentioned in the schedule only. Not granted. Judicial powers granted. This we have already discussed. One more thing, when it comes to Tribes Advisory Council. So Tribes Advisory Council is a council which consists of the members of Legislative Assembly, tribal members and CM as a chairman. Every fifth schedule state has a TAC. Tribe Advisory Council plays a recommendatory role. It plays a link between the tribes and the authority and the legislature. So TAC is again an important body, and they can ask where can you find TAC? You can find TAC in the fifth schedule, not in the sixth schedule. Six schedules have autonomous district councils. They don't have TAC system. Now comes judiciary. Now judiciary is one institution of the constitution which can be found in both federal and unitary feature. Hierarchical judiciary is a unitary feature. That judiciary has been arranged in hierarchy. Independent is a federal feature. That judiciary is independent of the various wings of government or the various hierarchies. Now you have Supreme Court, you have High Court, you have subordinate courts. Supreme Court has original jurisdiction, original in form of fundamental rights. You can directly go to Supreme Court, but the word original is not mentioned. Original is mentioned for Article 131, where center state disputes would directly go to Supreme Court. It also has advisory jurisdiction under Article 143, where President can ask the legal, can discuss the legal issues, seek the recommendation, seek the help in the legal issues. Then you have the High Court. Now, when it comes to the High Court has appellate jurisdiction. High Court is part of appellate jurisdiction. Supreme Court also has special leave petition. What is special leave petition? Let us say if you are not happy with these two systems of judiciary, if your case is not being resolved, you have not got the justice, then you can ask for a special leave petition. Through special leave petition, the Supreme Court will admit your case. So a leave has been granted to you, a special leave that yes, you can come to the court, unless you cannot directly go to the court every time. Okay, so all the matters of the subordinate court from the High Court not necessarily will go to Supreme Court. Supreme Court, if allows SLP, so through SLP you can take your case to the Supreme Court. Now SLP is not a matter of right, neither it is the duty of Supreme Court to give you SLP. It is a pure privilege of the court. It's a constitutional power mentioned in the Constitution where court may or may not grant SLP. Fine. Next thing comes that there was another topic in news, that is the advocate on record. Now, what is advocate on record? Advocate on records are the practitioners who are allowed to represent the case, who are allowed to present a party in the Supreme Court. So let us say if you want to go to Supreme Court, if you have some case in the Supreme Court, you cannot present your case to the Supreme Court unless you have an AOR with you. Your advocate and AOR will represent the case. These AOR are mostly responsible for the drafting of the petitions, drafting of the cases, drafting of the petitions. So advocate on record is a post created through the Supreme Court rules only, and this particular post is granted through examination. So there is a eligibility examination criteria. Advocate on record is currently only in Supreme Court, not in High Court. So if a person becomes advocate on record, that means he's a registered person with the Supreme Court and he is eligible for all kinds of petitions filing, draftings in the Supreme Court. If any other person wants to go to Supreme Court, he has to take the AOR route. He has to meet a AOR. AOR on his behalf will file the case in the Supreme Court. Next comes, when it comes to the promotion of justice. So there was an idea given to the Supreme Court. In fact, that was given by the Attorney General in 2021, that we should establish the various courts over the country. This is called as the Court of Appeals. He used the term Court of Appeals. We can come up with the Court of Appeals. What are the Court of Appeals? Court of Appeals are nothing but they are the courts which are to be established countrywide to de-burdenize the Supreme Court. So Supreme Court shall be made as a court of constitution, a constitutional court, whereas there can be 4 or 5 zonal Court of Appeals. Court of Appeal East, West, North, South. So what these Court of Appeals, they would be the final appeals, final Court of Appeals in non-constitutional matters. Non-constitutional matters. So this is just a proposal. This Court of Appeal is nothing but called as regional benches. Okay. So can regional benches be created? Yes. Should Supreme Court only sit in New Delhi? No. Because 130 says that Supreme Court will sit in Delhi or other such places as Chief Justice of India with the approval of President may allow, may approve. Okay. So again, regional benches can be created. Constitution, this article 130 does not mention regional benches. Okay. It means that yes, it can be done. In fact, 229th Law Commission report also says that yes, such kind of regional benches can be created. Now, another topic is alternative dispute resolution. What exactly is alternative dispute resolution? As we know, when it comes to the dispute resolution can be done through courts, or second way is outside courts. This outside court is called as ADR. This ADR principle is lately being accepted in India as well. Currently, we have just passed 2023 Mediation Act, which talks about how the mediation has to take place, what shall be the institutions involved. Similarly, over here, when it comes to the alternative dispute resolution, so you have various ways of alternative dispute resolution. Like one is arbitration. Arbitration means a procedure in which one or more arbitrators are selected mutually. So there is an arbitrator. That arbitrator will give the judgment. Over here, the judgment is final and binding because you have only appointed an arbitrator. There are court of arbitrators. So two parties who are into certain kind of dispute, they will go to an arbitrator. Now, what kind of cases will go into arbitrator? Only those cases will go into arbitration which are the non-cognizable offenses, or one thing, or which are the civil offenses. Now, over here, the judgment of the arbitrator shall be final. So, whatever arbitrator says has to be followed. Second thing is negotiation. It is again a kind of an indirect communication between the parties in which we try to come up with, okay, do one thing, try to solve it amicably, don't go to the court. Then you have conciliation. Conciliators are the neutral third party people. They just conciliate. They again ensure that how the cases can be best solved, how we can solve this problem in a very less time. This is how they apply various techniques. They sit with the people, they sit with the parties and try to try the negotiations between them. And then you have ultimately the Lok Adalat. Lok Adalat is again a kind of ADR, alternative dispute resolution. So let us see what exactly is Lok Adalat. Lok Adalat is nothing but it has been created as a ADR. Okay. So what kind of cases? The non-cognizable cases of civil or non-cognizable cases of criminal nature also goes to Lok Adalat. Lok Adalat, whatever has been settled in Lok Adalat shall not be questioned, shall not be taken up in any court of India, because this is where you have decided to go to Lok Adalat. So something which has been decided by Lok Adalat has to be followed. Why? Because people went to the Lok Adalat by their consent only. So no appeal of the Lok Adalats can lie anywhere in the country. So this is first thing with regard to the Lok Adalat. Second thing is that these Lok Adalats are deciding the matter through the principle of natural justice. So they don't have to follow any particular law, any particular act. They just take the action as per the natural justice. They try to ensure the benefit of both of them, or to both the parties. They try to ensure benefit to all the party. Okay. So whatever is the final judgment of the Lok Adalat, that judgment is the judgment of a civil court binding on the parties. Okay. So you cannot say that I don't want to go, I don't want this particular judgment to be implemented. Okay. I want to go to other court. No appeal can be filed in any court of India. Next is Gram Nyayalaya. How Lok Adalat is different from Gram Nyayalaya? What exactly is the difference between these two organizations? Gram Nyayalayas, again, these are the statutory courts created to ensure justice at the village level. Gram Nyayalayas. Now, what exactly are Gram Nyayalayas? Let us discuss. Now, the Supreme Court, it recently said that we need to take care of the Gram Nyayalayas. We need to do the audit of the Gram Nyayalayas. We need to see that whether they are functioning as per the Act or not. So, Gram Nyayalayas are the statutory courts created through the Gram Nyayalaya Act of 2008. 114th Law Commission said that we need to have Gram Nyayalayas which will give the access to the people on their doorsteps. So, it is the justice at the grassroots level. Now, when it comes to the Gram Nyayalaya Act, the idea was to reduce pendency, to provide speedy, affordable justice and bring legal redress to the rural population. So, this is the basic idea of Gram Nyayalaya. Next is what exactly legal basis is, that it is derived by the law, it is run by the law. Jurisdiction is criminal and civil as per the first and second schedule of the Act. So, there are laws, there are crimes given over here. Gram Nyayalaya will be able to decide in those crimes. What exactly is the status? It is presided by judicial magistrate first class. Now, location is nothing but a panchayat level or a group of panchayats. Appointment of Nyayadhikari by state government will appoint a Nyayadhikari who will take care of the Gram Nyayalayas. Then appeals from the Gram Nyayalaya will go to the session court, the criminal appeals, and the civil appeals would be done by the district courts, civil courts. Then evidences not strictly bound by Indian Evidence Act can decide as per the natural justice. Execution of orders, nothing but they are called as civil court decrees. Geographical extent applicable all the India except the northeast. Why? Nagaland have their own tribal panchayats, Arunachal, Sikkim, they have their own tribal panchayats dealing with the matter. Then doctrine of basic structure was also in news this time. What exactly is the doctrine of basic structure? So it is not defined anywhere. What is basic structure? Neither it's a constitutional mechanism, not defined anywhere, nor constitutional, neither defined. So nor it is constitutional, neither defined anywhere. Okay, neither it is defined anywhere. Now what happened recently? The Supreme Court upheld Uttar Pradesh Madrasa Education Board Act 2004 with some exceptions. What are the exceptions? Again, it is the part of the law only. So it said that it is not against the basic structure doctrine. Court says that it is not against the basic structure doctrine. Now we know what exactly is basic structure doctrine. How it came, we know the story. But again, it is not important for prelims. Cases involved. What is basic structure doctrine? Rule of law is basic structure doctrine. Independence of judiciary is basic structure doctrine. Secularism is basic structure doctrine. Now court has said socialism is also basic structure doctrine. So it is an ongoing list. It is an ongoing list. It is an ongoing list. Okay. Done. Next. Again, 10 schedule. What is 10 schedule? 10 schedule was implemented by 52nd Amendment. It talks about defection. What is defection? MP joining other party, MP MLA. MP MLA joining other party. Next is not following whip, defying whip. Defying whip is also defection. Then exception. If 2/3 MP MLA join any other party, it is not defection. Speaker resigning, not defection. Okay. So in these scenarios, or if there is merger of two parties, then also it is not defection. Merger is also, if in merger few of the MPs doesn't want to join other party, it is not defection. So defection means that if any person is not following the orders of the party, any MP, MLA, and he has been removed from the party, then he would be booked under anti-defection law. And who has the power to disqualify? So let us see disqualification. Quickly revise this disqualification as well. It was in news. So disqualification is of two kinds. One is the constitutional disqualification. Another is the statutory disqualification. The provisions of statutory disqualifications are given under RPA, section number 8, then section number 123, then constitutional given under article 102. Grounds: if a person holds office of profit, if a person gives away citizenship, if a person unsound mind, undischarged insolvent, Who has power? President has power. Here, convicted of crime more than 2 years punishment. Okay. Next is conviction. Post conviction you have, if any person finds guilty of doing malpractices, unable to submit audited expenses of election. So here if a person is disqualified, he will not be able to contest the election for 6 years. Okay, 6 years. And apart from this, over here, if any disqualification has been done, the court in Lily Thomas case has said that the person should be immediately removed from seat. Immediately removed from seat. Earlier he had 3 months in hand to contest the case. Okay. Now these are done by President. When it comes to 10 schedule, in case of 10 schedule, Speaker is responsible. Speaker is responsible. Next comes whip. What do you understand by the term whip? What exactly is whip? Whip is not mentioned in the Constitution. There is no mention of the term whip in the Constitution. Then what exactly is whip? Whip is nothing but it is a kind of direction given by the party to its members in the House so that they can follow the rules, they can work in unanimity, and the decorum in the House can be maintained from the party side. Decorum as in everyone should vote in the same manner, should go in the same manner. So whip becomes an official position. So to impose this whip, the party appoints chief whip. Now you have a chief whip act which talks about the various privileges to be given to chief whip. Who will get a chief whip? Only the party who have more than 10% members in the House. They will be able to get their chief whip appointed by Speaker. So Speaker will give them chief whip status. So neither mentioned in the House nor mentioned in the rules of the Parliament. Based on the conventions, we have taken it from the British system. Next comes NOTA. NOTA was in news. Now Indore recently received highest NOTA votes. So NOTA was introduced with the EVMs by Election Commission. So it is also basically right to secrecy of the voters' choice. Second is consequences. There is no legal consequences as of now. We have to see when any particular constituency gives a very high, the number of votes of NOTA are highest than any number of votes, then there might be re-election. Next comes how elections are conducted in US. So this is again an important topic. So US has recently elected a new president. So elections in US to the president post are held, conducted every 4 years. The same elections elects the president, the same elections elects the vice president. Citizens, they vote indirectly. What citizens do? So almost it's a 6-7 month long process. The citizens start choosing their electors. They elect their electors from their seats. So the citizens are indirectly electing the leaders. So they choose the electors then choose the leaders. So a natural born citizen of US can only become president, whereas in India, a citizen of India, natural born, naturalized citizen, citizenship registration, or through any format, if person is a citizen at this particular time, the person can be is eligible to contest the president election, can win the president election. At least 35 years old and resident of America. Now, electoral college system in US. So, college, it's a body responsible for electing, often used to refer the constitutional body that appoints the key positions. Members are electors. This we have already discussed. Total electors, there are 538 electors. Okay. So, every area has one elector. So, complete US is divided into 538 electors, 38 constituencies. These 538 constituencies have one elector every constituency, and that one elector is responsible for the final election. Whosoever gets 272 votes wins the election. So each state has designated number of electors roughly based upon its population. By voting for a candidate, voters are actually choosing that candidate's party designated electors for their state. This we have already discussed. Next, when it comes to the 73rd Amendment, 74th Amendment. So when it comes to 74th Amendment specifically, we have different kinds of local bodies. Usually students are confused. One is we have a municipal corporation. So what is municipal corporation? Technically with those cities who have more than 1 million population at this point of time. Municipality population between 1 lakh and 1 million. Notified area, these are the developing towns. They don't have the basic amenities. They are just becoming the municipalities. Then you have the town area committee. So these are again the small towns which are basically has a minimal authority. They don't have much services over there. Then you have the cantonment board. Cantonment board consists of some public as well as some the military personnel. So cantonment board are managed by the Ministry of Defence. So my cantonment board also conducts the election because it consists of the civilian population as well as the non-civilian population, the defence population. Then you have township, then you have port trust, and then you have special purpose agencies which are created for certain development. Let us say new city is to be created. So new city would have SPA, special purpose agency. That means a new body would be created, and that body would be responsible for the maintaining that particular city. Next comes Lokpal. Lokpal. Now, as we know that India Against Corruption Anna Andolan demanded for a Lokpal on the lines of Swedish ombudsman system. Now, who is this Lokpal? The Lokpal is responsible for ensuring zero corruption in all the sections of government, from Group A till Group D services, even in the PMO. Recently, a new Lokpal has been appointed by the President of India. Now, it is a statutory body through Lokpal Act of 2013. Idea is to inquire into the allegations. If any complaint has been submitted to Lokpal, the Lokpal will direct the CBI to conduct the inquiry, investigation. Depending upon the report of the investigation, the Lokpal will direct the authorities to file the case. So this is how the Lokpal works. So it's an anti-corruption ombudsman. Now, appointment process. So the Lokpal is appointed by the President on the recommendation of a selection committee. Selection committee consists of the Prime Minister, Speaker of Lok Sabha, then Leader of Opposition in Lok Sabha, CJI or Judge of Supreme Court, one eminent jurist, and this is where these people together, they gave the name, select one name and submit that name to the President, and according to this particular report, the President appoints the Lokpal. Composition. So there is a chairperson, which is usually the former Chief Justice or the retired Judge of Supreme Court, and other members, 8 members. So that there are total 9 members. Now these 8 members basically are judicial members, and 50% of them would be the SCs and STs. Then there are non-judicial members, then 50% of them would be SC and ST. So this is how 8 members are divided into judicial, non-judicial, and then there should be from the certain categories. Now when these members, what are the eligibility of the members? The members should be having a fair, they should have They should be either the former Judge of Supreme Court, former Chief Justice of High Court, whereas the other members would have at least 25 years of experience in fighting public corruption. The same goes with the Lokpal. Lokpal should have a tenure of at least 25 years. He should have the knowledge of anti-corruption, vigilance, finance, banking, law, management. So these questions, this is how the statements are formed in UPSC. Now tenure 5 years or 70 years of age, whatever comes first. No reappointment, not eligible for reappointment, cannot hold any government office after retirement. Jurisdiction, Prime Minister, ministers, ABCD, officials of central government. PM has an exception. Complete PMO is not under Lokpal if Prime Minister has taken some decision on international relations, on security, public, atomic, space, energy, then complaints cannot be filed. Okay. In case a judgment has to be given against the PM, so full Lokpal bench considers the initiation of inquiry unless the full Lokpal bench, 9 people doesn't sit, and after those 9, 2/3 does not give in writing, does not approve that yes, the PMO has to be inquired. Till the time PMO will not be inquired. The powers of the Lokpal, obviously the power to inquire and power of a civil court. So these are the powers. Next comes Delimitation Commission. Now what exactly is Delimitation Commission and what powers Delimitation Commission has? If you could recall Article 82 of the Constitution, Article 82 of the Constitution says that, after every census, there should be readjustment of population. Readjustment. So readjustment means the population should be redistributed. Currently, let us say we have 2.5 million population per MP. Okay. So this is how, let us say, if in any constituency the members increase, the population increases, then that has to be offset with the other constituency. Now coming to the point, so Delimitation Commission, 4 Delimitation Commissions have been constituted till date. Delimitation Commission can be constituted by the President only. So President has power to constitute Delimitation Commission. Now what is the news? The news was that in 𝐂𝐶 case, the court upheld its power to review Delimitation Commission if the decision is arbitrary or unconstitutional. The court inquired into the delay, why there has been delay in forming the Delimitation Commission over here. So that means court said we can judicially review. Court said if you will completely bar us, so we will not be able to do the justice. So court can do the judicial review of Delimitation Commission. It's a constitutional body? No, it is a statutory body. Delimitation Commissions are constituted by the laws of parliaments. Okay. Next. ⅓ Law Commission. Now what exactly is Law Commission? Look, it is not a constitutional body, it's an extra constitutional. It is a non-statutory body. Let us first discuss about Law Commission. Law Commission gives advice for the reforms in the laws. It is a advisory body. So it's there is a full-time chairman. There are 4 full-time members. Then there is Secretary Department Legal Affairs, Secretary Legislative Department, and no more than 5 part-time members. Chairman has to be a retired judge of Supreme Court, of Chief Justice of High Court. Time frame is 3 years. So every Law Commission gets 3 years to submit their law, their recommendations, and the government is not bound by them. It depends from government to government. It is merely recommendatory body. Now next is Central Consumer Protection Authority. Now these kinds of questions are highly factual in nature. Okay, so just keep in mind in the previous topic I said Law Commission is a non-statutory, it's an executive commission. Okay, there is no law for Law Commission. Just keep this fact in mind from the previous slide. CCPA regulatory body as per the Consumer Protection Act, so that makes it a statutory body. Investigate, refund, recall, impose penalties, protects consumer rights. Nodal ministries, Ministry of Consumer Affairs. Then you have the composition. There has to be a chief commissioner. Then there has to have an investigation wing and district collectors. Next comes virtual court. So Kerala has recently started a virtual court in which you can file, you can present your case, you can file the petitions, you can challenge the petitions without going to the court. Filing stage, case registration, admission, appearances, hearing, passing of orders and judgment, everything would be done online. It is a virtual court, first of its kind in the nation. Next comes first information report. Zero FIR. What exactly is zero FIR? Now recently what happened, the Ministry of Home Affairs has directed union territories to ensure that zero FIRs recorded in local languages carry translated copy. So there should be a translated copy. It should be forwarded to the states where different languages are used. So that means if you are filing any zero FIR in Tamil Nadu and you are sending it to Uttar Pradesh, so there you need to attach a translated Hindi copy. Now what exactly is zero FIR? First we need to understand, then we would be able to understand the context. What is FIR? First information report. So the first information the police gets when it just registers the case, that is FIR. After FIR, a lot of investigation happens and final charge sheet is filed. FIR is not the charge sheet. Based upon the FIR, the information given, the circumstances told, the police investigates the matter and then goes to the court and submits the charge sheet in which charges are pressed. Now FIR, the term FIR is not defined in the Indian Penal Code, fine, in any other law. But police regulations or rules, information recorded under section 154 is known as FIR. So any information given to the police as per the CRPC's FIR. Now FIR is nothing but a first information given to the police. Now what is zero FIR? Let us say a crime has happened. A crime has happened, or a person wants to register case somewhere else, file an FIR somewhere else. Usually you must have seen that police used to file the FIR based upon their jurisdiction. So if let us say something has happened here and you are not present over here, you want to file an FIR somewhere else. So that was not feasible. So Verma committee in 2012 said that zero FIR should be made possible. So zero FIR means that speedy redressal of the victim and timely filing of the FIR. So where the idea is that if any person comes to the police station and tells him that some case has happened, in that case the question comes whether that case has happened in their jurisdiction. The answer is no, it has not happened in our jurisdiction. It has happened in someone else's jurisdiction. Okay. And the matter is serious, matter is cognizable. Crime is cognizable. Cognizable means police has to file an FIR. And police has to file the FIR by itself. Police has to file the FIR by very itself. So matter is cognizable, matter is serious. In that scenario, the FIR has to be registered. Why it is zero? Zero is because it is irrespective of the jurisdiction. So later on, the Tamil Nadu, let us say the Tamil Nadu will file, any police station in Tamil Nadu will file the zero FIR, whereas the matter pertains to Uttar Pradesh, then the case would be transferred to the Uttar Pradesh, and accordingly Uttar Pradesh police will deal the matter. This is zero FIR. Next comes right to disconnect. Now this right has been provided to the people who have been working and who are working. So right to disconnect means you should have a work-life balance, you should have a work-life harmony. Once you are off from the office, you can just disconnect your emails, you can just disconnect your phones, you are not obliged to respond to the official calls, official mails. This is called as right to disconnect. So law does not ban employers from contacting workers after hours. Instead, it gives a right not to reply. So they are not saying that the company should not contact the workers, whereas the workers have a right to disconnect. They will not pick up the calls. It has been introduced in Australia recently. So Australia joins about the 24 other countries. Obviously, the countries of Europe, Latin America have such provisions. Similarly, France happens to be one of the first to implement this right. Next, there was another right in the news, that is right to repair movement. Now, what is right to repair movement? If you would have seen that companies have been making the gadgets obsolete. You have purchased something and you are not able to find the spare parts of your gadget because your gadget is 5 years old, 6 years old. You went to the company, you went to the service center, you asked for the various spare parts. The gadget is not working. It requires screen or anything, connection, charger pin, etc., etc. And this is where the Consumer Protection Authority has also come up with a report that we should make sure that more and more spares should be available of the old gadgets. The gadget should not be dumped like this, and we are preparing for this right to repair. Maybe soon you will get this as a fundamental right, but not as of now. It is not a fundamental right, so don't get confused. Right to repair is not any right as of now in India. It is a right in the European nations. Now, I guess this covers almost all the topics which were in news in past 1 year, from which the questions can come. And obviously, we have uploaded other videos as well. So, joining all these videos, you would be able to cover your polity, and this is done from my side. So I hope that you will be able to make best use of this video, and I wish you all the very best. Hope you come out with the flying colors, and see you for the mains 2025.